Civil rights advocates are crying foul over a decision handed down by the U.S. Supreme Court today.
The court ruled that police officers who fail to read suspects their Miranda rights can't be sued. Joe Dana explains the potential fallout.
The power of police to interrogate a suspect is enormous. The Miranda warning is intended to protect suspects from being unfairly treated. Today's decision weakens that protection. The 1963 arrest of a man in Phoenix led to a landmark Supreme Court ruling that is a household phrase. Police are required to tell suspects in custody of their Miranda rights, notifying them of their right to remain silent and their right to speak with an attorney. On Thursday, the Supreme Court ruled suspects who are not notified of their Miranda rights do not have the option to sue police for damages later.
It is another consistent weakening of the Miranda doctrine.
ASU law professor Gary Stewart wrote a book on Miranda rights. Stewart says the decision by the Supreme Court is based in good faith and is a sound legal decision reflecting the conservative makeup of the court. However, he warns it could do harm.
Well, it will encourage that tiny minority of police officers, it's a tiny minority, who abuse these rules routinely, who solve crimes by lying to suspects, by not telling the suspects what their constitutional rights are.
This is one of the most completely wrong opinions of the Supreme Court I've read recently.
ASU constitutional law attorney Paul Bender is more critical of the court, saying the right to sue should not be taken away.
The reason why there's a federal statute that gives you damages if your constitutional rights are violated is because the federal government, Congress, thinks that if your constitutional rights are violated and harms you, you ought to be able to recover damages.
The decision means police officers will have one more level of immunity as they do their jobs. Joe Dana, 12 News.